Good morning. I'm Gary DeWaal, and this is Bridging the Week for September 24th to 28th, and today is October 1st, 2018. The Commodity Futures Trading Commission brought and resolved multiple enforcement actions alleging manipulation and attempted manipulation, coordinating such actions with parallel disciplinary proceedings by relevant exchanges. The CFTC also filed an enforcement action in federal court against an introducing broker and an associated person for illicit insider trading involving futures contracts traded on ICE Futures US. This matter was not settled and appears headed for litigation, although a prior disciplinary action involving the same facts and parties was settled last year by the CFTC defendants with ICE Futures. Separately, a federal court in Massachusetts said the CFTC has authority to bring an anti-fraud action against defendants in connection with their offer and sale of a cryptocurrency on which a specific futures contract has not been based. The regular Major League Baseball season has wrapped up, and now it's time for the Fall Classic. So I can get out and root for the home team Yankees. Let's get started. The CFTC, the Chicago Mercantile Exchange, and the North American Derivatives Exchange brought and resolved charges against an individual claiming he engaged in a cross-market manipulation scheme involving trading on CME Group exchanges to impact prices to benefit his binary option positions on Nadex. Additionally, two persons associated with a grain merchandising firm previously sanctioned by the CFTC for attempted manipulation of wheat futures settled separate charges brought by the CFTC and the Chicago Board of Trade. In the first matter, the CFTC filed and settled an enforcement action against Davis Ramsey, claiming that from at least April 2015 through May 2017, he traded futures on two CME Group exchanges on multiple occasions to artificially impact prices in order to benefit binary options positions he owned or controlled on Nadex. The CFTC alleged that during the relevant time period, Mr. Ramsey purchased Nadex binary options that allowed him to make money if prices of certain Commodity Exchange Inc. or CME futures contracts traded above or below designated prices at specific times. The CFTC charged Mr. Ramsey with manipulation and attempted manipulation, as well as engaging in a prohibited manipulative or deceptive device or contrivance. Both Nadex and CME filed separate disciplinary actions against Mr. Ramsey based on his purported wrongdoing. To resolve the CFTC enforcement action, Mr. Ramsey agreed to pay a fine of $325,000 and disgorge profits of $250,636. He also agreed that for 5 years, he would not directly or indirectly trade or be involved in any transaction for any commodity interest regulated by the CFTC and permanently be prohibited from trading on Nadex. Separately, Mr. Ramsey agreed to pay a fine of $135,000 to CME and $145,000 to Nadex. In the second action, the CFTC brought and settled two enforcement actions against traders associated with Lansing Trade Group for their role in an attempted manipulation of the prices of certain wheat futures and option contracts from March 3rd to 11, 2015. The two traders were Adam Flevin and Peter Grady. Both the CFTC and the Chicago Board of Trade charged Lansing with attempted manipulation to benefit its own futures and option positions in enforcement actions filed in July 2018. Lansing resolved these matters by agreeing to pay aggregate fines of $6.55 million. The CFTC charged that Mr. Flevin and Mr. Grady orchestrated the attempted manipulation on behalf of Lansing. To resolve their enforcement actions, Mr. Grady agreed to pay a $250,000 US dollar fine and Mr. Flevin a $125,000 US dollar penalty. Mr. Flevin also agreed to a 4-year trading ban and Mr. Grady a 9-month trading ban on all CFTC supervised trading facilities. Both Mr. Flevin and Mr. Grady were also subject to parallel Chicago Board of Trade disciplinary actions for their role in Lansing's attempted manipulation, each settled by agreeing to pay additional fines equal to the amount of their fines to the CFTC, as well as other sanctions. The CFTC also filed a lawsuit against EOX Holdings LLC, a commission-registered introducing broker, and one of its associated persons, Andrew Gazinski, for illegally sharing their customers' trading information with one customer, as well as impermissibly trading the one customer's account on a discretionary basis, relying on other customers' trading information. According to the CFTC, from approximately August 2013 through May 2014, Mr. Gazinski provided confidential, non-public information to one customer regarding the trading activities of other customers, purportedly, quote, knowing or with reckless disregard of the fact that the information would be used for trading, end of quote. In addition, charged the CFTC, during this time, Mr. Gazinski also traded for the one customer while having non-public information regarding other EOX customers, and on more than 100 times executed block trades against other customers for the benefit of the one customer. The CFTC charged that these alleged actions evidenced a breach of defendants' obligation to protect confidential customer information and constituted the misappropriation of material non-public information by both defendants. Last year, EOX agreed to pay a fine of $442,500 to resolve charges brought by ICE Futures US that from August 2013 through July 2014, it may have failed to adequately supervise two of its employees in connection with their execution of block trades and handling of non-public customer information. Two of EOX's employees, Mr. Gazinski and Eric Torres, consented to payment of fines of $50,000 and $7,500 respectively to resolve related charges. I have no insight why the CFTC action was also not settled in light of the prior IFAS settlement, but stay tuned. And finally, a second federal court has ruled that the CFTC has jurisdiction to bring enforcement actions against persons engaged in purported fraudulent activities involving cryptocurrencies. In an action against MyBitcoinPay, Randall Crater, and certain relief defendants, the U.S. District Court in Massachusetts held that cryptocurrencies are commodities as defined under applicable law, and that the CFTC's authority to bring enforcement actions under its fraud-based manipulation authority extends to fraud cases that are not grounded in illicit market conduct. In August 2018, a federal court in Brooklyn, New York, reached the same conclusion in a CFTC enforcement action against Patrick McDonald and Cabbage Tech, Inc. The Massachusetts court claimed that the digital coin at issue in this action, MyBitcoin, was a cryptocurrency and satisfied the definition of a commodity under the Commodity Exchange Act. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. That's www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week. And until the next regularly scheduled edition of Bridging the Week on October 15th, let's go Yankees and ciao.